All right, I think we'll get going. Let's start with that witness depot dispute. And I went through this and said, okay, who said the grandmother provided the water? No, I've got two charts here. But it seems to me there's no dispute, but after 2018, is it Leela? Is that how you pronounce it?
Leela.
Leela, at least at home, drank the real water exclusively, correct?
Right. Well, that was the only liquid she drank, but it was the only water.
Yeah, so, yeah, for water, that was what she drank.
That's correct. She, 2018, when she started kindergarten, her dad was putting in real water into her thermos, and she was drinking the real water in her thermos every day at school. And after she's drinking the real water in her thermos for a few weeks, that's when she becomes symptomatic and suffers a liver failure injury. And the grandmother that didn't live with her, didn't provide her with the real water, has no relevant information related to any of this. It's just, it's a relevance issue and a proportionality issue. They want to question her about additional real water that she may have drank, years before this, which just has no bearing on this and is not a reason to drag this woman through a deposition.
Well, let me ask you if I understand this. Now, Mr. Kava, father, says the water went to her, Leela, and some of it went to the grandmother, and some of it, a few, went to workers, correct? That's what the mother said. I'm sorry, that's what the father said. Now, the mother said, Jill said, went to her, went to Leela, went to the father, went to some family members, and that was purportedly Mrs. Kava, they didn't name anyone else. Some friends and some of Ms. Raw's co-workers and students. Now, I don't think the grandmother knows the dispute between those two, but that is somewhat different.
Yeah, but I think what Eric's trying to focus on is the temporal time period. So school started that year sometime in August, 16th, 17th of August. And then October 30th, we have the incident with Layla. Okay, so that's really the relevant time period. And I think both sides experts agree that, it's an exposure during that time period, not an exposure from the year before 2017 or 16. And I think that's where the grandma really comes in during that earlier time period. So I don't really see why they think, the grandmother's all that relevant, but.
May I be heard, Special Master Hale? I represent Costco.
Of course, go ahead.
Thank you. Yeah, I think the issue is that there is evidence suggesting that she may have information pertaining to consumption of real water for herself personally, at the very least, from 2015 through 2018. The testimony of the mother about all the other people that may have drank real water in part was related to 2015 and 2017. But she also did say that those types of the other people who drank real water, including herself, the husband, and family members, may have continued in 2018. So I think in light of that, and because I've offered to make accommodations in light if there's an issue in terms of trying to limit the length of the deposition, agreeing to do it wherever the grandmother may be comfortable. In light of that, and in light of that, this entire case is about the consumption of real water, that this should be an area that we're at least permitted to explore, and that the standard isn't that the plaintiffs in this case are the only persons that may comment upon the consumption of real water, when it's evident that the grandmother is in the best position to know about her own consumption, not the parents who seem to not even have their testimonies align with one another. And that in light of that, in light of what is at stake, that we're talking about what is reasonably calculated for purposes of discovery, that we should be allowed to explore it.
Well, but the issue is limited to 2018, the beginning of the school year, is when Layla started getting the real water. And then by October of that year, she has a medical event of some type. That's the only period that would be at issue, isn't it?
Well, they claim in the fact sheet that consumption began in January of 2018, not when the school year began, which is in August of 2018. And I think that's also consistent with what the father testified to. But there is suggestion from the parents that she could have drank it earlier. But I think even ignoring that, even if you only treat 2018 as the relevant year, the testimony of the mother is that the others, apart from Leela drinking real water, continued beyond 2017.
But the question is, what do you propose to ask the grandmother? If you know who drank the real water that came into Layla's house during the year of 2018 up to October?
About her consumption of real water, how much, what that looks, what she recalls of it, what she knows of Leela's consumption. The amount of real water consumed is relevant. You're talking about what the plaintiffs are claiming is a toxic exposure. So dosage, and anyone who has information about that, it's relevant to explore that.
But I'm trying to find out the scope of your inquiry, because she didn't live with Layla and she didn't care for her. So the issue would be, in the year of 2018, what real water, how much real water did you drink that was bought by your son? Is that correct?
Yeah, well, in part, the father also claimed that Leela could have drank real water at the grandmother's home, that he can't speak to that. But in whatever water that the grandmother is consuming is necessarily water that Leela is not consuming.
Water the grandmother consumed that was purchased by her son.
Correct, which, yeah, I'm not exploring if the grandmother may have purchased real water on her own. That's not what I'm trying to get at. I'm getting at purchases that were made by either the father or the mother that the grandmother ultimately consumed.
So the question would be, how much real water did you consume in 2018 that was purchased by your son or daughter-in-law? That's the first question.
That's the first part. And then also, to the extent she may asking if she about what she knows of Leela's consumption, if anything.
But those are the only two areas, right?
Essentially, I'm assuming that they're not seeking, since plaintiffs are objecting to the deposition entirely, that they're not seeking to introduce the grandmother as a damages witness or something to that effect. So it wouldn't be for that purpose.
But the scope of your test, the scope of your inquiry would be the amount of water that the grandmother drank that was purchased by her son or daughter-in-law, correct?
Correct.
Or the amount of water that Layla purchased in 2018. I'm sorry, that Layla drank in 2018, if you have any idea.
Yes, or if and to close the loop to make sure that it's not an outstanding question whether Leela may have consumed it before 2018, because we put some of the testimony in our letter to you, but there's some speculation from the father that, oh, maybe she drank it before if it was at my mother's house.
All right, so the two areas are, how much real water product did the grandmother drink that was purchased by her son or daughter-in-law, correct?
Yes.
And how much real water did Layla drink in 2018 or before, if you know?
Yes. And clarifying when the grandmother may have consumed it. If she did in fact consume it, when, if she recalls.
Well, we don't care what the grandmother consumed. The issue is, other than real water purchased by her son or daughter-in-law, issue is how much real water did Leila drink in 2018, if you know?
Right. I'm suggesting we care about what she consumed. If, for example, the grandmother drank 10 bottles of real water in 2018 that the parents purchased, those are 10 bottles that were not consumed by Leila. So in that way, it's relevant.
Is there any reason we can't take, there's so few questions. So is there
Well,
any reason we can't take this demo by written?
We can try,
Interrogatory?
we can try that. See, we'll try that if you want. I mean,
I just don't see what the valid grounds are for a single deposition. I don't see the proportionality argument or how the standard has been met here when especially in the grand scope of things and the limitations that have been the meet and confer efforts I've tried to offer, why we're not allowed access to this witness, a regular fact witness, why we're not being permitted to subpoena her. If there's a test, if there is a declaration or something that's being attested to that she is not fit to give a deposition, that's another issue, which I don't think has been demonstrated here. But just blocking off a witness we have reasonable grounds to believe that she has relevant information here. And proposing that it be done by written discovery, it's not the same as being able to actually get the testimony of a witness and being able to judge their credibility in person or by Zoom.
So what is her age? Do you know?
I don't know the exact age, but she's, I believe, in her 80s.
And she had a stroke.
Right.
But we don't have any medical information to say she can't sit for a deposition, correct?
no.
I don't know. I only know what son told me, but it's not enough to say that she's, incapacitated or anything without talking to her myself.
All right. Would you anticipate your deposition would last more than an hour?
No.
I don't think this woman can last an hour. Personally.
Oh, we don't have any information on that.
Well, we have talked to husband and wife, and they don't think she's capable of giving that. They just don't think that. We haven't gone and looked through her medical records. No.
Well, I'm inclined to let the deposition go an hour, limited to the scope of water consumption by the grandmother that was purchased by her son or daughter-in-law. And the second issue would be the amount of water, real water consumed by Leila up until October of 2018, if she knows. But would you like to have a time to get a medical statement or something if she's capable of sitting through that?
Let's see if we can arrange it, because personally, I don't think this is going to really result in any big revelation of information. So probably it's better 5 hours to try to go through it.
All right, well, let's give it a shot. And you or whoever's present, I would suggest you be present with her, one of you.
Yeah,
If you feel you need to stop the deposition, just stop it.
yeah,
Go
we
back
would
and
probably
revisit.
ask her to come into our office and
That's where it ought to
at
be.
least have one, if not both of the parents present.
Well, they're litigants, so
Right.
they can.
Right.
All right, so
Can I
we'll
ask for clarification, you limited the range to ending in 2018. I believe the plaintiffs are claiming that consumption continued into 2019. So I just wanted to clarify that point.
Well, I don't really need to put it a
Okay.
year. I don't think.
Okay, that's as long as that's clear. And then
Yeah, I just thought the issue was the year 2018 to October, but I don't want to raise an issue we don't
Okay.
need.
okay. And does the grandmother require a translator?
We don't know yet.
Okay,
If it does, we'll let you know.
thank you.
All right, so it's limited in scope to the amount of real water purchased by her son and daughter-in-law that she consumed. And then the other issue is the amount of real water consumed by Layla that she's aware of.
Yes.
Okay. Is there anything else on that issue? No. I received a letter, or actually a notice from Kemp and Pepperman about the proposed schedule for today, agenda for today. And the second item was Burris' failure to file an expert report, but he's been withdrawn, right?
No. You also got a letter from Chad Fears on February 21.
What date? I thought he was,
February 21. So
I
some
thought he
of the
was
parties,
withdrawn.
some of the parties have withdrawn him. Sid's and Hannah has not withdrawn.
Okay, so who is still using him?
Sid, USA. And Hannah.
Says Master Floyd, this is Chad Fears. We have Hannah, the SID entities. I think Milwaukee hasn't withdrawn him. And maybe just give you some context. This is more of a belts and suspenders kind of issue. And is he going to come to trial? Most likely, probably not. He was called by one of our experts and asked questions. And so, an abundance of caution, since he's the president of the company, we listed him as a non-retained expert. And what he relayed to our expert is in the expert reports that he has provided and has been provided to everybody. In my letter, I outlined, to the extent possible, the 4 subpoints of 16.1A2C. And so we don't think he needs to provide a report. Mr. Odou, if he wants, can have his expert just give him a call, like we had our expert, Bob Hale, and I'll let other defendants talk about their expert RevCheck, who also called this president of a company considering their machinery. And we just put it there in the sense of damned if you do, damned if you don't. If we didn't put him there, someone would say, well, your expert relied on him. He must be an expert. Why didn't you put him there? Okay. We put him there. Now we're told he should have a report. It's just a conversation that our expert asked about a certain machinery.
So in other words, your expert, Mr. Hale, called Burris to talk to him about the equipment that was in the facility.
Yes.
Did he document that in his report, what was said?
Yes.
And do you intend to call him in your case?
Mr. Hale or Mr. Burris?
That's your expert. Burris.
No, we listed him as, no, I'm not going to be calling him and flying him to Nevada. It was just, he was our expert. Hale talked to him and we just listed him as an expert because he is the president of the company of which the conversation of which Mr. Hale relied on.
Yeah, I don't know that Mr. Hale was the big problem. I think RevCheck's more of a problem because RevCheck basically got an opinion from this guy and he's incorporated into his opinion. So it's an opinion from an opinion. There's no expert report for the first opinion. So, I mean, factual descriptions, like when the machine was made, its dimensions, maybe even how it's supposed to work, that's one thing. But an opinion that if they don't hook up something, that it can cause contaminants and potentially cause acute liver failure. I mean, that's an opinion, right? So they can't backdoor it by saying called up and talked to them about it. There's no expert report. That's what we object to.
So whose report refers to the opinion of Burris?
Well,
Checking Hale.
Hale does, but I don't think Hale really gets into the opinion area that much. Maybe a little bit, but RevCheck is right on top of it, okay?
Floyd, we've also objected. I don't know if Will was done.
No, I'm done.
Here's the issue, Floyd. He's been withdrawn by UNFW, who became RevCheck, and by that Beverage. He's not been withdrawn by Hannah and the SID entities and scientific instruments. Hannah, the SID entities and scientific instruments don't have a cross-claim or third-party claim in this case. What they want to do, though, is they want to use Hale, they want to use this non-disclosed expert who didn't provide a report, who didn't provide a belt and suspenders, who's required to provide a report, to smear real water and say, oh, well, this must be the cause of plaintiff's injuries. They want this guy to speculate as to what caused plaintiff's injuries. It has nothing to do with hydrazine. It has everything to do with just a smear. It's a distraction. And we've objected to it. The CMO requires an expert report. If they wanted this guy to testify, he should have provided an expert report. We are and do have objections to Hale and RevCheck because, again, this is a strict liability case. There's no comparative fault in strict liability. So we think this is jury nullification and we think this is improper and this guy should be stricken.
Well, we generally, I haven't looked at the CMO in this case in a long time. I generally require a non-retained expert to provide a report if you call him. I don't know if it's in the CMO.
Yeah, it's, the CMO is silent in this case.
But the expert for SID USA and Hannah Instruments expert relies on an opinion of Burris informing his opinion.
And, you know, it's a way to try and protect it and say, oh, well, you know, it's not me that's saying it, it's this other guy. Well, that's not proper.
Special Master, maybe I can leave some clarification. First, Hannah and the SID entities have not disclosed RevCheck as their expert. It was Hale. And Hale just had a conversation with him about his product and the HIPAA filter. I understand Mr. Odou says that this is a smear campaign. I disagree with that. And I don't know what Hale is going to do more, given that Mr. Odou in the last two cases has admitted liability and causation in each trial, saying that everything bad that happened to all these plaintiffs, we take blame for. So I don't know, having Mr. Hale talking to Mr. Burris about a machinery is a smear campaign.
Here's the problem. Here's the problem. He didn't just talk to him about the equipment. He obtained his expert opinion. Didn't he?
Well, he didn't take the opinion that, as was related by Mr. Kemp, about the other processes that RevCheck did. He just said, here's the machinery, and this is what type of HIPAA filter is required for that machinery.
That's an opinion.
Well, that's also probably in the manual.
Well,
So, I mean, there is a difference in Mr. Hale than Mr. RevCheck.
any report to reference an opinion by Mr. Burris.
I have to go back to Mr. Hale's report, but my understanding was just an understanding of how the machine works.
Yeah, I think Mr. Hale's more on the fact side. I gotta go back and read myself. The RevCheck's way over on the opinion side.
Is RevCheck going to be used by anyone?
Well, RevCheck is,
Yes, RevCheck will be used. This is Jim Neale for UNFI.
Jim, who do you represent?
UNFI in Whole Foods Market.
All right, here's what you need to do. We need to hurry on this too. You need to give me your proposal. First of all, have a 16.1 to see if the council involved can agree on what needs to be stricken from the expert report for reports. If you can't agree, shoot them to me and I'll decide.
time deadline for that.
Well, it's up to you folks. I'm not having to track the case.
Well, the only reason I ask is because we have rebuttal reports due on a week from tomorrow.
Doesn't matter to me once you get them to me. When do you folks suggest getting them to me?
We can do by Monday, Tuesday.
I can give you a week.
I'd rather not have a week because the rebuttal report deadline.
Okay, well, let's do it by, you want to do it by the 27th then?
Yeah, that's Tuesday.
Yeah, well, you folks are gonna have to get on the horn tomorrow or Monday. And get on the phone and try to resolve it. And if you can't resolve it, everybody, I know what the issue is. I don't need briefing. I just need, this is what we think should be stricken and this is what we think should be stricken.
So Special Master, I want to make sure I understand. We're talking about Burris and his designation, correct?
No, we're talking about a reference to Burris's opinion in another expert's report.
Okay, so, but that's not, all right, I didn't even realize that's before you were on an agenda. So we're moving to strike other experts' reports?
Isn't that complicated? That's what we're doing. If your expert or someone's expert calls up Burris, a non-retained expert, and gets an opinion that he utilizes in his report, that's no longer a non-retained expert. He's utilizing that expert's opinion. And you can't do that without having that expert also produce a report.
Well,
So a report that refers to an opinion by Burris, I intend to strike that limited amount, not any reference to facts or anything else. Burris might talk about the model numbers and those type things. But anything, and it's hard for me to say yes in a vacuum, but I want to see what the claimants think is an opinion, an expert opinion, and then I want to see the response to that, and then I'll decide it.
very good. I understand what's at issue now. Thanks.
Oh, what about the independent medical exams?
Yeah,
I didn't really understand what that issue was.
Okay,
Something
yeah.
about plaintiffs who were,
Okay.
someone has requested IMEs for plaintiffs that were evaluated by Dr. Sands.
Yeah, and I think this ties into 4 too. So Dr. Sands, this psychologist, Dr. Sands interviewed parents of the 6 baby cases. Dr. Sands did this questionnaire that results in what they call raw data. That's 4. And so first of all, they want Dr. Sands' raw data, which we see 2 problems with. First problem is it's starting to intrude on the rule that, you know, we give it the expert files. Assuming we can get past that hurdle. The second problem is, I understand that through these NRCP 35 exams, they want to recreate the raw data themselves. So that raises a couple questions. First, if they're going to recreate this raw data, why do they need to do this exam to, you know, if we give them the raw data? But second of all, and they've raised this, you know, the timing of the rebuttal report's a week from tomorrow. So when are they going to do these 35 exams online? And then the other problem is the structure of the 35 exam. They don't want to comply with the new rule that we have the right to have someone, you know, be physically present. So that it all ties together, and I just bring it all up because I think it's a little more complex than.
Well, Sands has to provide all the facts upon which his opinion is based, and then all of his opinions. He's got data he didn't use as a basis for his opinion. He doesn't have to produce it.
Okay. The data I would concede probably is the basis of part of this opinion.
Well,
So if we have to concede it, we will concede it. But-
yeah, well, that's part of
I don't wanna get
the
into-
expert rule is that
Yeah, but
it's,
the bigger issue, we've agreed not to exchange expert files. We pretty, you know, we've taken like 50 expert depositions. There's not been one file exchange. You know, so I don't want to throw out that rule by giving them this raw testing data. So I don't mind giving them the raw testing data. That gets us right back to this 35 examination they're going to do. If I'm giving them my raw testing data, it should be a simultaneous exchange with their raw testing data. If that's what they're going to achieve through these 35 examinations. That's my understanding
Well,
of what they're trying to
if they
do.
do an IME under Rule 35, they have to give you everything that was gathered during that IME.
Okay, but if they do the IME if I give them my raw data now, they've got time to file the rebuttal report by a week from Friday. If they do the 35 exams later, and then file something, then I don't have the right to do a rebuttal on their raw data.
Well,
Special Master, this is Dawn Davis. I'm the one who wrote you the letter raising this on behalf of Milwaukee Instruments. What I have requested from Plaintiffs' Counsel is that their psychology expert directly provide his raw testing data to our psychology expert. The testing that was done by the plaintiff's psychology expert, these are proprietary tests that are used by psychology folks. Whatever the scores are from the tests make up the raw data. Psychologists don't share raw data. They don't share these tests with anybody aside from other psychologists. I am not asking for an expert file. I am simply asking, which is routine with psychology experts, that Dr. Sands directly provide our expert, who's Dr. Eckhoff, the raw data so that he can evaluate it. If we get to the second issue of the Rule 35 exam, of course, Dr. Eckhoff will have his own raw data from whatever testing he conducts. Absolutely, I agree that Dr. Eckhoff ought to provide his raw testing data to the plaintiff's expert. This information never exchanges hands with any attorneys. This is information that is provided exclusively between the psychology experts. So that's the first issue. At this point, if Dr. Eckhoff is provided with the raw data right now, there simply is not enough time for him to prepare rebuttal reports within a week for 6 different plaintiffs. So again, that's just the first issue. We've also made a request for the Rule 35 exams. And as I noted in my letter, I'm happy to work with the Plaintiffs' Counsel to come to some sort of a protocol in agreement with these, but this is obviously not going to happen by the 1st of March. And, you know, we have things to work out with regard to observation of a psychological exam. And I think it was Mr. Kemp referenced a new rule, and I'm not sure what new rule he's referring to. But I guess I'm asking for 2 things, Mr. Hale. I'm asking for the raw data exchange. I'll never see it. None of the attorneys will ever see it. I'm not asking for a job file. And then I'm asking for an extension on this rebuttal disclosure deadline of March 1st so that we can work with the plaintiffs to come up with a protocol for the Rule 35 examinations.
Floyd, I'd like to add, Real Water has a rebuttal expert that would like to get the raw data. We're not asking for a Rule 35 exam.
And
well, psychological.
Right, it would.
Mr.
We wouldn't see it. And we understand that this data is confidential and it's not shared with attorneys typically.
Well, I will let the doctors talk to you. Is this Lewis Edcock we're talking
Well,
about?
Yeah, that's one.
Yes, sir.
Ours is Dr. Bailey, who
It
knows.
was,
Dr. Bell.
if it's going to be a mutual exchange of raw data, that's one thing. But I think what counsel is proposing,
Well, it can't be mutual because
well,
you came first.
well, we came
Right.
first. They just asked for this 35 examination. This is a new issue. So
And-
they get an extension of time on their rebuttal report to do a 35 examination. It should have been in the initial report that was filed, 2 weeks before Monday. A Rule 35 is not really a rebuttal report.
Mr. Hale, this is Sam Mirkovich. I represent the carrier plaintiffs. No request has been made on me for a independent medical examination. I don't even know what the request, who they would be seeking to examine, but no request has been made on us. This is the first I've heard of it. And, without hearing more, we object to any such examination taking place.
Sam, no request is pending as to your plaintiffs.
So there is no formal request for an independent medical exam? Just a-
They called Eric up on Valentine's Day, February 14th, which is 6 days ago, after the initial expert disclosures were due, and they asked for this 35 exam. So how can this be timely?
Well, it's not. Why
Your
was,
Honor, regardless of the Rule 35 exams, or not, I'm sorry, not Your Honor, Special Master Hale, Dr. Edcoff still doesn't have this raw data, and he's got to have it to prepare a rebuttal report. We can argue about what a rebuttal report is and isn't, but that data is needed for him to prepare a rebuttal report. And again, even if that is provided right this second, he's not going to be able to meet the March 1st deadline because of all the dilly-dallying that's gone along.
well, but why didn't you ask for, I mean, even I know what this case is about. It's about the medical condition. And you waited until after the discovery cutoff, the expert cutoff to request an IME?
Your Honor, these psychological experts, to my understanding, and I'll admit I'm new here, my understanding is this is the first time that these type of damages have been raised.
Rule 35, it's the same as in federal court. It's an independent medical exam. It's the same in 20-something states, but you don't wait till after the expert discovery to do an IME. Why wasn't it done before the expert discovery reports were due?
Your Honor, excuse me, Special Master, I had no idea that they were going to be retaining a psychology expert or making this claim. So the only way that my client can address this is on rebuttal.
When did you disclose SANS?
With the initial expert designations,
Which was when?
2 weeks before Monday, whatever that was, the 5th, February 5th.
Now, the judge set these dates, right?
Yeah, it's joint disclosures.
Yeah, I mean,
Yeah.
I didn't, by the way, I didn't set these dates. So the initial exam, I don't have the scheduling order in front of me. The initial expert exchange was February 5 and the rebuttal is what?
March 1st.
March 1.
Well, that's the problem. You get 10 days to provide the report. I mean, when did they ask you to do the report? I mean, to do the exam?
35 on February 14th. For six people if you include carrier.
With Louis Edcoff? All of them are with Dr. Edcoff?
I think.
Has he given any idea as to how much time he needs to schedule these? Dr. Edcoff?
At this point, he's not holding any dates. He said he'll do what he can to get this done as soon as possible. But again, it's 6 different plaintiffs. And he also doesn't have the raw data to evaluate in advance of these evaluations or examinations.
Yeah, I think they're starting to confuse the issue. Okay, raw data, I can see the argument that would be rebuttal. But these 35 exams, they should have done those before the deadline, February 5th. So they're trying to get 2 things. They're trying to use this raw data rebuttal excuse to go back and do an original 35 report.
You know, that's my problem is the initial expert exchange, February 5, should have included your IME report.
Again, Special Master, my client had no idea or indication that these plaintiffs were going to be making these types of claims until we received Dr. Sand's reports on February 5th.
If I may, the neuropsychologist examines cognitive issues. There's been it's never been an issue in these cases that any consumption of real water could lead to cognitive issues. It's a brand, and in fact, I can't speak to all the plaintiffs, but I know the Cave family, they were asked about psychological or any types of issues at deposition, and they denied such claims exist. So I don't think the defendants were put on notice and anyone was expecting that now there's being a claim that the consumption of real water is causing cognitive impairment.
Was there any testimony about cognitive impairment before February 5 this year?
I'm not aware of any.
You aware of any?
Well, by council's own admission, I mean, they were inquiring about this with the parents long before. They wanted to have an expert evaluate it
Yeah,
to,
but you're not going to create the issue. If the plaintiff isn't raising cognitive issues, you're not going to hire an expert.
Wait, the cognitive impairment comes from the fact that these children all had acute liver failure. They were flown up for these transplants. That's where the cognitive impairment issue comes from.
Yeah,
It
but that
doesn't-
would be from
it
an
doesn't-
MD.
yeah,
A psychiatrist, a psychologist
Right.
can't testify to that. Not even a psychiatrist, right? He's not an MD.
I don't know what Dr.
they're a
Sims is.
PsyD, neuropsychologist.
Well, that's just a psychologist to put neuro in front of their name.
Yeah.
I'm well aware. Cops one now too,
I
but
mean,
they're not an MD, so
But now they're giving you excuses for why they didn't do the initial designation. You know, if they thought that they were sandbagged on the initial designation, they should have filed a motion to extend the time period for initial reports on February 5th, okay? Or they should have, they shouldn't try to tie this into the raw testing and say, oh, now we get 35 examinations and now we get a new deadline for filing our initial expert reports. That's what they're asking for.
well, I mean, I don't know if we have time for briefing on them, but if there's been, if no witness, a parent or anyone else testified about psychological injury, I don't know how they would know to do a report on.
How would a layperson have the expertise to testify that the acute liver failure caused psychological injury? A layperson doesn't have that.
No, but there was no indication of a cognitive or psychological injury to Layla, correct?
I don't think. that's-
Exactly.
Was there anything in the medical statement?
No, there's nothing, there's nothing in the medical records or that anyone was, that we were not aware that is being asserted. So why would we provide an expert on February 5th that is talking about cognitive impairment? That was a completely new issue, and it's new as to plaintiffs as well, because they've never designated this expert before for their other plaintiffs.
And they do a rebuttal report. That's one thing. But now they're saying, oh, in addition to getting the raw data, in addition to doing the rebuttal report, we get to go do 35 examinations, file another initial report. I mean, that's just not appropriate.
And we did in the disclosures and disclose damages related to future mental anguish, anxiety as a result of this incident. I mean, these are kids who went through an extremely traumatic medical trauma. To us, it's obvious that there's going to be some psychological impact, mental anguish in the future. It was disclosed. They were asking the parents about it in depositions. Yeah, the lay parents, they don't understand what this entails. That's why you get an expert.
So your report was February 5 and their request for an IME was February 14.
Right. Right.
And these mutual exchanges always cause these problems.
That's why you get a rebuttal report. If there's some new area that they didn't anticipate, they get the rebuttal report.
Well, it was 9 days later, they asked for an IME. My worry is how long it would take Edcoff to kick out an opinion.
Well, I think, first of all, they don't want to comply with the rules on 35 examinations now where we physically get to have someone present. They've indicated they don't want to comply with that rule. So that's going to be the first problem. So I don't think these proposed NRCP exams are ever going to happen. Unless we waive our right, which we're not going to do. So we're tying the whole expert discovery into a 35 examination being proper.
Well, it's a medical case. I mean, we used to an IME on any complicated medical case. I'm worried about the timing though.
Well, if we give them the raw testing data, I mean, give them a brief extension from the 3-1, that doesn't kill me, okay, because we still get the expert deposition done in time. But This 35 examination is completely inappropriate, I think.
Special Master, it's not inappropriate for all the reasons that, we've gone over. Again, simply saying that we're going to make a claim for mental anguish gives nobody any indication that those type of claims are going to be anything other than garden variety. So we're just asking for an opportunity to fully defend these new claims on behalf of our clients.
So they know that there's a claim for mental anguish, but if we support it with an expert, they're surprised. But if we don't support it with an expert, they're not surprised about the claim. What kind of argument is that?
A neuropsychologist deals with the different issues than mental anguish. Neuropsych is used specifically for the reason to show that someone is neurologically, cognitively impaired. It's completely different from saying you had pain and suffering or mental anguish.
Well, I'd be inclined to allow the IMEs, except I didn't set these deadlines. The court did.
Well, plus, we still haven't addressed the primary problem with the IME, which is that we're entitled to have someone there physically. And every time we've done a psychological examination since that rule came out, the psychiatrist has refused to do that. So if they're telling me Dr. Etkoff is fine with that, that's one thing. I don't think that's the case.
It's definitely not the case. And I'm not sure what rule Mr. Kemp is relying on as authority that he's entitled to have an observer.
So, Eric?
It's the new law, Assembly Bill 244. It was passed in the last legislative session, signed by the governor in June 2023. It plainly allows us to have an attorney or anyone we hire present, and they can record and audio record.
It's a
video.
statute, it's not part of NRCP 35.
Yeah, it's an amendment to a statute. Passed in
What
Assembly.
statute?
Special Masters Chad Fears. I just have the NRCP 35 up, and maybe people can look at that. And Mr. Kemp is right that you can have someone present, but Part 4A says the party may have one observer present for the examination unless subpart 1, the examination is neuropsychology, psychology, or psychiatric examination. Whether this is, I'm just pulling this off the internet, I'll be honest, a case text, so maybe the statute is different, but we may want to just review that.
Are you Rule 35
Yeah, NRCP Rule 35.
would be. And Eric, you think there's something other than Rule 35 on IMEs?
Yes, because of this exact issue, because of the wording of NRCP 35 and precluding this, there was a big push to say, no, we got to change the law that allows this, because the way that the rule is being enforced by excluding representation or someone on behalf of the plaintiff being subjected to these these mental examinations, we need to change the law, which was done in AB 244, which passed to specifically address this problem, to specifically authorize someone who's sitting for an IME in a
Sir,
lawsuit.
do you have the NRS site on it?
We have everything.
Yeah, it's Assembly Bill 244.
Yeah, but that's the last session or what?
Yes, 2023, 82nd session, 2023.
Well, what's the NRS? Do you have that yet?
It says chapter 629 of the NRS is hereby amended. I don't have the exact.
Maybe I'm not up on the times, but this issue was decided in 2021 by the Supreme Court in the Lyft case.
That's why the statute was amended in the last legislative session. We get pushback like this all the time from defense counsel, aren't aware of the law.
But you're still not telling us what the statute is.
We will send the statute to you.
Serve the statute, just e-serve it today. I'm inclined to allow an IME, except we're going to blow all the deadlines the judge gave.
This is a bigger issue, Floyd. Some of the federal courts have ruled the statute unconstitutional. This is not something that we can just say, here's the answer. You're going to have to look at all this stuff. And
And they've ruled the new statute unconstitutional?
federal court has, and
Who
at
did
least
that?
one state court has. I have the state court one open. That was Judge Wren ruled it unconstitutional in November. And I'll also send the federal one too.
But wait a minute, that was the one that was taken up and argued from the Supreme Court a couple months ago, right?
The one
reversed.
I'm looking at was November 2023.
Well, there was another one from Judge Reynolds. Am I confusing?
My only point is it's a nebulous issue. It's not something where we can just say, here's the answer.
Well, law's law.
Well, every time there's been a dispute between a statute and a court rule, oddly enough, the Supreme Court rules in favor of the court rule, including term limits, and everything else. But, well, those are the two issues. I would be inclined, can someone find, I need to know, what's the date of our trial?
Well, I mean,
June, what is it?
May
One
28th.
stack for
May-
May.
May 28th is what we're trying to get, but yeah, it's set for May 20.
What's that?
There's a motion for firm setting for May 28th, but it's set on May 20 right now.
well, let me propose something, at least to get something moving here, okay? So long as we don't abolish the rule that we don't have to give expert files, if we give them the raw testing data on the agreement that they're going to give us their raw testing data if they ever develop any, I don't mind giving them the raw testing data and having them have whatever they want to do rebuttal reports, as long as it's reasonable enough that we can do the deposition. So if they want 14 days after we give them the raw testing data to do rebuttal, I don't have a problem with that. If they want 21 days, I'll even listen to that. If they want 2 months, I don't think that's reasonable.
I think 21 days is perfectly reasonable, and I absolutely agree that if Dr. Eckhoff does the Rule 35 exams and has raw data, that data will be provided to the plaintiff's psychology expert.
And again, for the carrier plaintiffs, this is Sam Mirkovich. Exchange of data, I don't have any issue with. I object to any IME of the carrier plaintiffs. It doesn't sound like one's been requested or is being requested, but I just want the record to be clear on our position.
Well, don't raise it, it'll be untimely. No, what IMEs have been requested? Just Layla?
I received an email requesting IMEs
On whom?
of, well, our expert did not examine the children individually. He just met with the parents. So it's not exactly clear what they're looking for, but my assumption is that it would be within the context of what our expert did, which was the meeting with the parents. That's what this raw data relates to. It relates to interviews with the parents. I assume they're looking for the same thing.
Is that what Ed Koff will be doing?
Special Master, I haven't had a chance to talk with him about this because we just don't really have any of the information yet. He hasn't looked at the data. He knows basically what tests have been administered, but it could be his opinion that it wasn't appropriate for only the parents to be evaluated. So I mean, I gotta think that the request is to do the Rule 35 exams of the actual people who are asserting the claims, which would be the minors.
Well, we would strongly object to that. First of all, there's never been a Rule 35 request made for that. I mean, there's never been a formal Rule 35 request.
Well, that's
made.
what I'm asking, because I follow the e-service. Has there been any formal request for an independent medical exam? Just a
far as I
contact
know, there was
saying
the email,
schedule
yeah.
one?
No. Other than the email as at 9 days after we disclosed our report.
Floyd, to move this forward, what we would suggest, we just want the data for our expert. We would suggest that the briefing on this IME and anybody who wants to file brief can make their argument, but we haven't requested an IME. But, just to move things along so we can.
Well, let's
resolve
start
it
with
for the
this. There'll be a confidential disclosure directly to Dr. Louis Edkoff.
I think there was another expert.
moment. Yeah, ours is Dr. Bailey.
What's his first? I
I
don't
don't
know.
have their first name in front of me. I can get it while we're talking.
Joe, this is Matt Kaufman. Dr. Bailey's first name is Abigail.
Abigail.
Yeah, and I can provide her information to Eric and Brianna in a little bit.
Is she a psychologist?
She is a psychologist, that is correct.
Like the raw data can be exchanged. And then I'm gonna have to see some kind of briefing to justify an interview with anyone other than the parents.
I can't file a brief until I know what they want. So they should have to give us at least some indication of what this Rule 35 examination is. Because just now is the first I've heard they want to, examine the children as well.
The email, I'm looking at the email that was sent by counsel for Nevada Beverage. It says defense counsel requests expert examinations of plaintiffs.
Yeah, but our experts. Okay.
I mean, this is a completely different argument now that when they said, oh, this is a rebuttal, we had no idea. Now they want to do IMEs initially of
Plaintiffs.
the minor children that our experts didn't even individually examine. I mean, that's got to be far beyond the scope of rebuttal.
All I'm asking is before we do the briefing, we get a written post in our CP 35 exam, saying who they want to examine, what the exam is going to consist of, where it's going to be, just we're entitled to that because you're entitled to that to decide whether or not you should object to it.
Well, I'm inclined to right now allow an exchange of the raw data to the psychologists only, and then let Dr. Edkoff write his report based on that data. I'm inclined to let him interview the parents.
Well, that raises the question of whether we're going to follow the statute or not, which allows us the right to be there and record it if we want.
So I'm not sure Dr. Edkoff would do it like that.
I don't think he would do it because so far all the psychiatrists saying they don't want to do that.
I mean, the reason they don't want to do it is because it impacts the integrity of the testing, but that argument can be argued a different day. I'd be happy to work with putting together a proposed Rule 35 exam notice. In the interim, if we can have an order that Dr. Sands will provide his raw data to Dr. Edkoff, and it sounds like Dr. Bailey, and that, Dr. Edkoff can have 21 days after receipt of that raw data. I think that deals with the first part of this issue. And it sounds like we need to deal with the Rule 35 exam part amongst ourselves to some extent.
I think so, because I think it's untimely.
Yeah, it's.
But I would consider, why don't you find out, let's do this, try to work out an agreement on exchange of raw data. And at least do that part.
Well, we'll get the raw data to them as soon as we can feasibly do it and give them the 21 days after that. That solves that issue. And
So-
maybe that solves the 35 issue because maybe their doctor will say the raw data is fine with him.
All right, well, let's go through that phase and then somebody let me know where we are. And I'll go to both Bailey and Edkoff.
Yeah.
Oh. Should tell Dr. Edkoff that I haven't retired either.
How old's Dr. Edkoff now? He's got up there, right?
All right, is there anything else for the record?
There's some housekeeping stuff that.
Go ahead.
We wanted to get some schedules done, and certainly we just want to give you the heads up. I don't think there's anything that we can't work out amongst the parties. There was a letter sent by Shore on February 21st, just noting that the question about the parties redeposing some debt. Do you have it? I can give you the. Yeah, exactly.
Let me see it. I pulled all the letters. I saved all the letters for,
I think the Henry Martinez Sheriff Off thing is the easiest one, because I think we can just work on that ourselves. See any reason why Eric and Brianna and I and the other parties can't come up with a schedule, if those cases are gonna end up consolidated.
Yeah, I don't think we'll be able to have a problem.
all right, we'll try to work this out. Both of you, tell me when anything is an issue so we can get back together ASAP.
What if there's other issue?
Floyd, this is Colt Dodrill. Did you see my my letter dated yesterday regarding the agenda for today?
Oh, that was, yeah, Colt's letter. Colt
Yeah, I
signed
just
the
looked
letter,
at it.
Karen had the
Yeah.
name first.
Yeah,
Yeah, thanks.
that's what we were talking about.
Thank you. Yeah, I heard the Henry Martinez Sharpoff portion. I wanted to make sure we had time to address the expert deposition question as we're going into for the Wren Carrier Cavay case, making sure that we have a fair opportunity for those of us that weren't able to depose any of the experts in Gallagher get a chance, as you indicated on the May 9 hearing, to redepose them subject to those limitations.
Well, if they have a new expert report, you're entitled to redepose them.
Limited to
You're
that.
limited to that new part of the report, which would include Dr. Hudson, obviously. But people like Dr. Noushan and Dr. Hutt, for example, they don't have no reports in this case, so you're not entitled to redepose.
Yeah, that's not my understanding of Floyd's ruling on May 9.
That's the understanding that we had in the last case, and I don't know why we now.
You think that really was 3-9?
Yeah, I got it pulled up on YouTube. That particular special master hearing did not have a court report.
I mean, there's a
And
special
what's the
master
issue,
order.
redeposing an expert? I don't remember us talking about that, but it was
Well,
4
first of
months
all,
ago.
he was referencing May 9, 2024. I assume you mean 2023 there, right?
May 9, 2023, at about 20 minutes and 15 seconds in.
And second, we talked about this, and this was the rule that was adopted in the Hunwartzen case. We didn't redepose Dr. Hutt. We didn't redepose Dr. Cosnet. And by the same token, we didn't go back in and redepose, defense experts that were generic. So to suggest that you can go back and redepose a generic defense expert or plaintiff or defense expert this time, I don't see any basis for that.
I think that
Discuss it among yourselves and get something to me in writing. And everyone that has an issue, whether it's the IME issue, the exchange of the data issue, we're not going to reinvent the wheel on experts that were generically deposed. But if there's some reason to readdress something new on an expert, I'll consider that. But get everything to me as soon as you can when it's at issue so I can set up another hearing.
Thank you.
And Floyd, Jim Neale for UNFI, if I could just get clarification on one thing. I think you've instructed the plaintiffs to identify portions of the RevChuck expert report that they believe improperly rely on Burris's opinion. I think that was due on the 27th. And I just want to clarify that I'll have a day or two after seeing that to respond to it.
Yeah, I wasn't even going to do a formal order on that. We,
That's fine, as long as the timetable is agreed to.
right, so the Burris will be the May 27, and then that's the initial challenge to Burris opinions being in the other experts report. And then the response to that will be sorry, it's February 27.
Right.
February 27, and the response would be March 5.
Thank you, Floyd.
And is it just within the one report?
Well, he filed a new report for this case, so.
Well,
thought-
you'll-
is it a
whatever I
new
get.
report? He
No,
had
same report, Will.
the exact same thing? I thought
Yeah,
he had,
nothing new from Hunwartson.
okay.
Whatever the plaintiffs give me, the defense can respond to.
Thank you.
27 May 5.
March 5.
You're gonna make me work on my birthday, March 7th.
That's how quick you were.
Everyone that has an issue, get it to me in writing as soon as you can. If someone sees it, e-serve it, don't email it, e-serve it, the rule. And I follow the e-service. And then let me know if it's an issue, and we'll either do another quick Zoom or however we do it. As soon as we can get it up.